Good morning. Welcome to all of you, both here at Georgetown in the School of Continuing Studies building, and for the many, many people who are participating in this event with a live stream both from the United States and around the world. We really are glad to have you here. My name is John Mayo. I am a professor of economics, business, and public policy at Georgetown University's McDonough School of Business. And I'm also the executive director for our host organization today, the Georgetown Center for Business and Public Policy. Let me start with a completely obvious statement, and that is that we are in the middle of an election cycle. And one way or the other, we're going to have a new president in a few weeks. And that gives us, I think, a perfect opportunity to take stock of where we've been, where we are, and where we're headed. So to facilitate that discussion, we are extremely pleased to have the good fortune of having some of the nation's leading experts in the field of antitrust economics and law. I'll introduce them only briefly because they are so well known in the antitrust community. The first on my immediate left is Dennis Carlton. Dennis is the David McDaniel Keller Professor of Economics Emeritus at the University of Chicago Booth School. Dennis quite literally wrote the book on industrial organization, which is the foundational discipline for antitrust economics. Dennis also has served as the Deputy Assistant Attorney General for Antitrust at the Department of Justice, and has participated in many of the nation's leading antitrust cases over the last few years. So Dennis, welcome to you. Next, Debbie Feinstein. Debbie is a leading antitrust lawyer in the United States. Debbie also has served as an enforcer. Debbie worked as the director of the Bureau of Competition at the Federal Trade Commission. She is currently the head of the global antitrust practice at a prominent law firm, Arnold & Porter, here in Washington. Actually, her office is literally next door, so it wasn't a heavy lift maybe for her to be here, except the opportunity cost of her time. So Debbie, we're very grateful to have you. Debbie also has participated, I will tell you, in many of the leading cases over the last few years. Finally, let me introduce you to Bob Major. Bob is currently the Vice President of Cornerstone Research and Economic and Litigation Consulting firm here in Washington. He is also the head of their mergers investigation practice. Prior to joining Cornerstone, Bob was the director of economics at the Antitrust Division in the Department of Justice, where he participated in every single merger investigation for 9 years as director. So to say that Bob is steeped in antitrust is maybe a bit of an understatement. I said finally, but I really mean finally this time. I want to introduce my colleague and co-author, Mark Whitener. Mark is an adjunct professor at Georgetown's McDonough School of Business, where he teaches antitrust, a course on antitrust, and a very popular course entitled The Miracle of Markets, ? Not the Miracle of Markets, ! Nor the Miracle of Markets, yeah, right, but the Miracle of Markets, ? Mark previously served, before coming to Georgetown, as the Global Executive Counsel for Competition Law and Policy at General Electric. Prior to that, Mark was the Deputy Director of the Bureau of Competition, the Federal Trade Commission. So Mark has served as an enforcer. You'll see that all of the panelists have served both in private practice and on the enforcement side. So we think they are going to offer a tremendous set of perspectives. We're thrilled to have them. So I want to turn it over to Mark, but let me mention two logistical things right off the bat. Number one, as I said, each one of the panelists has participated either in recent cases or is active in ongoing litigation cases, so they will necessarily eschew mentioning and describing in detail those specific cases because they're very sensitive. That's okay because they're going to have some tremendous high-level insights. And so I just don't want you to look for particular nuances of specific cases here as a disclaimer. That covers all of them, I hope. And the other is that, of course, the views that you get from each of the panelists are their own personal views, not the views of their employers. All right? That was logistic item number one. Number two is more fun, and that is that we're going to talk for 45 minutes or so on the panel, and then we are going to recess. Those of us who are in this room are going to recess outside to the atrium, and we're going to feed you lunch and allow you to interact among yourselves. I know that we don't just have expertise on the panel, we have expertise in the room, so there's a marvelous opportunity for you over a sandwich to continue that discussion a little bit, and then we'll turn to some informal questions that can be posed to the panelists themselves over lunch, and then we'll end up around 12:30. So with that, let me turn it over to Mark to set the stage and begin the discussion.
Okay. Great, thank you, John. Good morning, welcome everyone. As John mentioned, and as you may have heard, there's an election coming, after which, one way or another, the Biden administration will come to an end. So this seemed like a good time to do a couple of things. Focusing on a policy area that this administration has sought to fundamentally reshape, and that's antitrust. So by announcing new enforcement policies, revoking old ones, bringing high-profile cases against big tech and other industries, changing enforcement procedures, proposing substantive rulemaking, and issuing executive orders. The administration has been on a mission to redefine not only antitrust enforcement policy, but really how we think about antitrust itself. So today we want to look back at how the Biden antitrust agenda has played out and look ahead at that agenda's legacy and what might be in store for antitrust policy going forward. Looking back, we'll ask our panelists to assess the key elements of the administration's antitrust agenda, the rationales that were offered to justify it, and the enforcement track record that the antitrust agencies have established. Looking forward, we'll focus on what, if any, lasting impact the past 3.5 years of antitrust may have. Have they moved the needle in the courts, in Congress, in academia, in the media, or in the court of public opinion? And before we wrap up, we'll touch on the potential directions antitrust policy could take after the election, when, as we noted, there will be regime change, no matter who wins. So with that, we want to begin by asking each of our panelists to give us their overall assessment of the Biden antitrust agenda, starting with Dennis, then Debbie, then Bob. Dennis.
All right. Well, my view of the agenda that was stated when the administration began was I was nervous. I thought the agenda was a dangerous one. It would have some benefits, as we might talk about a little later, but it would have lots of costs. The main summary, I would say, of what the agenda was or is to be more aggressive on all fronts. And one rationale for that is presumably studies showing that concentration increased in the United States, competition diminished, there was too much market power, and that might be due to lax antitrust. Well, such an aggressive agenda that they have pursued imposes costs. One of the costs is it deters mergers that raise no competitive issues because it makes merging so hard, make it complicated, you have to fight, it costs a lot of money. That's a concern that I don't see them paying enough attention to. Moreover, if you bring lots of cases, you're bound to win some, but you're also bound to lose some. And even the ones you win, you might win for the wrong reasons. You might get a wacky decision. Or if you lose a case, a good case, but it's not quite a very good case to win, and you get an adverse decision, it can make the case law not as good as it was before you brought the case. When I heard about the new agendas, listened to them, especially from the FTC, I was concerned because it sounded like they were going to depart from looking at consumer welfare, and consumer broadly construed would include workers, and instead replace it by not just concerns about prices and wages, but also concerns about things like the employment level, how particular groups are affected by the transaction, how the income distribution is affected, how political power is affected by the transaction. And that really makes me nervous, because a policy that says take account of everything is going to wind up extremely subjective and unpredictable. There was an attempt to, the agenda, and I think it's accurate, came through, to rely more on case law, indeed sometimes old cases that might not survive a Supreme Court challenge today, and to de-emphasize economics and to de-emphasize the role of efficiencies in our economy. There's a reluctance announced, and I think going forward has occurred, to consider remedies. There used to be you could fix a lot more cases. And finally, there seems to be little appreciation of the difference between being able to predict ex ante what's a bad merger versus looking ex post and saying, aha, prices went up in that merger, I shouldn't have allowed it. Unless you can predict in ex ante that something's going to be bad, it doesn't do much good to say ex post, I shouldn't have allowed it, because, you know, if you flip a coin, half the mergers are going to be good, half are going to be bad, let's say. Well, unless you can stop the bad ones without adversely affecting the good ones, you better think through your policy very carefully, especially if you think most mergers are good. Then it's not like you're flipping a 50-50 coin. You're flipping a coin in which many mergers are good, and you may be stopping them. So I'll just stop there and say that the agenda made me nervous when it began at its outset, and continues to make me nervous.
Debbie?
I want to talk about a couple of things. I mean, first, has this administration set out what it intended to do? In one respect, yes. You talk to people at cocktail parties and they now know what antitrust is. That was not the case when I started doing this. When I was a young lawyer and had the opportunity to go to the Federal Trade Commission, I talked to one of the partners outside my group and asked him, you know, whether this was an opportunity I should take, to which his response is, why would you want to go to that little backwater agency? If you really want to go to government, go to the Securities and Exchange Commission. I went to the FTC anyway. I mean, you have the chair of the FTC on the Jon Stewart show. I mean, this is crazy stuff for those of us who have been practicing for decades in our little narrow world. So in that respect, there's absolutely no question that they've got people talking about antitrust and the importance of the antitrust laws and the importance of competition in a way that hasn't happened in my lifetime of practicing. So in that respect, yes, they set out what they intended to do. Do they have people scared to merge and probably deterring some transactions? Probably yes. It's really hard to test that empirically. I haven't had a client who called up and said, well, I was going to do this 2 years ago, but now I'm not going to do it. But certainly they're thinking about it at an earlier stage. Are they deterring the ones they really want to deter? That's a different question. You do see a lot of the largest big tech companies still trying to do deals. They're still having to litigate to do them. So I think that that's a question mark as to whether or not they've done what they intended to do. You are always going to have mergers. You're always going to have challenged mergers, because the question is just, where is the line, right? Every administration, every enforcer has a line, and it's when you cross that. It's just a question of where the line is. Did they succeed in getting people to rethink whether or not the way we've been doing antitrust is right? Absolutely. And look, there can be a discussion about that. I'm not saying that the magic answer is one way or another way. For years it's been that mergers to monopoly, save a few, exceptional cases, get blocked. Mergers that go from 3 to 2 get blocked. Mergers that are 4 competitors going to 3 competitors, the data showed it was about 50-50. Is that the right place to have the line 50-50, or should it be 5 to 4s or 6 to 5s? Completely reasonable question that one could study and think about and say, look, have we erred a little bit too much this way, a little bit too much that way? All worthwhile things to think about. Where do I think they haven't accomplished what they set out to do? I don't think they've changed the law. I don't think courts are embracing what they have said, despite their efforts to turn some of their losses, potential competition, into wins because they got some good language. I think much of that language has been in prior cases. I do not think that they have moved it such that they can walk in and say, this is how we think about it, therefore you, judge, should follow it. We'll see. We're only now beginning to test the merger guidelines in a couple of the new merger guidelines in a couple of recent cases. It will be interesting to see what those decisions look like. But the current administration has been there 3 years. Even before the guidelines came into being, they were thinking about it differently. And yet, while you saw a lot more vertical transactions, you didn't see horizontal transactions that were moving the needle in the way they said they should be moved. They were not bringing the 6 to 5 cases, the 7 to 6 cases, the the combined market share is only 30%, but you should still block it. They weren't bringing those cases. Those cases weren't being challenged. So I find that interesting. I also find it interesting that on the conduct side, other than the really big challenges to high tech, they have brought way, way, way fewer conduct cases. They're not bringing the kinds of cases that I think are small but necessary and important. And we used to call them the cop on the beat kinds of conduct cases, right? You don't go just for the murder. Sometimes you need to stop the petty theft and the looting. To get the word out there, we're paying attention. We used to bring every year or so a trade association case or two to remind people that when trade associations, groups of competitors get together and agree on rules on how they will compete, that can be a problem. And I once had occasion to look back at the very first FTC report to Congress, and what was mentioned in there? Trade associations, the potential for trade associations to be anti-competitive. They haven't brought those cases. Why are they important? Because all of us in law firms write client alerts every time we see a case like that, and we remind all of our clients, don't do this stuff. There are clients out there who are beginning to think, if I'm not high tech, I can do anything I want because they're not paying any attention to me because they're resource constrained, they're so focused. So I think in that respect, they have maybe taken a step back. So, and the third thing that I will say is one thing I think that they've done which has not helped their cause is to be so critical of everything that has come before. This notion that there's been this 40-year failed experiment, that the enforcers, and they include all of us in the room, have been considered as a group, I've been named personally, as being asleep at the wheel during the time that we were at the agencies, completely ignoring the things that we did that made it easier for them. I jokingly say, if you think I didn't do anything, then stop citing the cases that we won, the 4 circuit court opinions in hospital mergers that reframed the law following on a long bipartisan effort to challenge hospital mergers. The cases that we brought that took the 2010 guidelines and really focused on, for instance, targeted customers, which is a concept that wasn't in the law before. So rather than saying, we're going to build on what's done before, they've sort of ignored and said everything that came before us was terrible. I think that's not good. If you don't know history, you're condemned to repeat it. Take some of the good and figure out what you can do to build on it. I think that has been a necessary impact. And somebody once accused me of taking it too personally. That's not why it upsets me. It upsets me because it has affected the morale at the agencies in a way that there has been an incredible amount of departures. And I cannot emphasize enough how important the historical memory at the agencies is, and the loss of those people has not been a good thing for antitrust, and that's why the rhetoric has me concerned. So let me stop there.
So both Debbie and Dennis have made a lot of great points. I'm actually sitting here remembering, Mark, the question you raised included the executive orders. And I frankly had forgotten that when I walked in the door. That was a big part of the agenda, was the whole administration was going to be more focused on competition. Haven't really seen that. I've at other regulators who aren't antitrust focused, they have that. It's part of their orders, but it doesn't seem to change anything about the way they're doing things. So let's focus on what does seem to have been the place where they tried to change things at the agencies. I would jump off where Debbie ended, the critique of the past. When I look at the cases that this administration has won, when the outcomes that they've achieved, they're not any different than the cases that I would have recommended in any administration. I started in the Clinton administration, worked into the Trump administration. So throughout all of those, whoever was in charge, those are cases that I would have said, yeah, let's bring that case. We can win that case. The ones they've lost are ones that I would have said, we can't win that case. They haven't moved the law, and that's actually a good thing, because a lot of the agenda or the critique of, the previous crop of enforcers just were asleep at the switch. I have the distinction of being the person who looked at one of the cases they always point to, and they say, how could you have let Google Maps and Waze merge? Well, guess what? The same things that make people think, oh, that was obviously going to raise some competitive issues, made us look at it. We did look at that. Does anybody really think that Waze was going to unseat Google in everything that Google does? If you did, you should go talk to the judge in the Google case, because he's looking for a remedy. If the remedy is as simple as divest Waze and they will replace Google or be a huge competitor to Google, it's an easy fix. Nobody believes that, right? Nobody, when really put to it, nobody believes the things that they say were obvious. The previous generation of enforcers just didn't take these things into consideration. The cases, in terms of the outcomes, come out where they do because the law has been influenced over time to reflect a lot of nuance that is important to competition. What I see, and what Dennis articulated as the scary part of this, let's not think about what we've learned about what ought to be the law. Let's go back in time to what the law was once upon a time when just being big was bad, and when that was the nature of what we challenged mergers on. What we've learned, the things that we've learned that we've added to the law, the considerations we've put on that, they help us distinguish things like, okay, is there something special about Waze when Waze wasn't owned by Google that's going to make them uniquely positioned? Why do we care about uniquely positioned to challenge Google? Well, we care about that because you literally can't have a company that repeatedly pays everybody who could possibly come up with a map software, right? I mean, Microsoft still has a map app. Apple sort of has one. Anybody could really write one of these things. You can't pay the entire, profits at risk of the monopoly benefit that Google has. If you believe that that's a huge premium, you can't pay that every time somebody could theoretically come up with something that's not unique. Theoretically, you could pay it once, right? Or you can agree to negotiate and pay some portion of it. But it just doesn't hold together logically to say that anybody who at all has a business that is in any way related to, I've picked on Google a lot, but any of these tech companies or any other established firm, that they ought to be forced to be competitors to that company, that they can't recognize that, hey, the best way to get my product to market, my innovation to market, is to work with the industry leader in a related space. That's a great way to help people get better apps faster. It's an efficiency in economics terms. It's a practical reality in the law. It's part of the nuance that the current administration's agenda seems to have been, let's try and get that out of our considerations. That's not where the law is, as Debbie mentioned. So they haven't really had success in changing what happens in outcomes. What that's left is just the fear factor, the raised costs that Dennis mentioned. That fear of, is my transaction going to meet some just disconnected with the law sort of challenge? Is it going to be put through the ringer of, can I hold the financing together long enough to get to court, which most deals can't? In the face of the core facts here are, there are thousands of mergers that meet the filing threshold every year. Every year. Of those, maybe 50 to 100 get investigated at all. Have any reason to be investigated. And of those, maybe 10 get an in-depth investigation, and of those, maybe 1 in a normal year gets challenged. That's the 50-50 coin flip that Dennis started with, the odds are actually more at the level of 2,000 to 1. Okay? We ought to be worried about a regime that is using the leverage of an administration to say, since we're going to have a policy of just raising your costs, we're going to dictate the outcomes in a way that don't match with what the court is doing in terms of discouraging all those 1,999 deals that should have happened. We're going to have a policy that's going to say, we're just going to play crazy. We're going to flip a coin, essentially. That's going to make the economy bring you good apps slower, bring you good innovations slower, lower costs less often. It's going to be less good at doing all the things that all those other mergers actually achieve. And it's going to put political power behind how we do antitrust, what the policy is. And what I've seen in my time, I think I mentioned how long I've been there, most of those administrations, policy didn't change, really. I mean, you had a different decision maker, and they had different priors about what was likely to be true. But at the end of the day, the facts in the case were the facts in the case. The law was the law. The decisions were made on those bases. In recent times, for this Biden administration, but the one before it as well, what I've seen is a lot more, let's investigate these guys just because we want to raise the costs. There was a lot of hullabaloo made about the fact that the antitrust division under Trump was investigating all these mergers of little tiny cannabis companies. Okay? Why? Well, one could guess. Some people did, but using antitrust as a lever to punish the bad companies just doesn't seem like what we should be doing if we recognize that competition is the core fundamental building block to an efficient economy, to an economy that innovates and brings good innovation to customers quickly. All depends on competition. We shouldn't be jeopardizing that to accomplish some political empowerment to just treat or extract more from some targeted corporations.
Okay. Well,
May I jump in here just real quickly before we leave the agenda part of this, because one of the manifestations that seem to me to be most visible in the shifting emphasis of the current administration was the sort of emphasis in merger cases on the possibility, Section 7 possibility, that a merger should be prescribed where the effect may be to substantially lessen competition. And there was a lot of emphasis on that may, and it seemed to give lots of energy to the prosecution side. Is there a sort of, Dennis, you started off with a phrase, you were a little nervous about this administration. Does that emphasis add to your nervousness?
Well, actually, I wrote an article about this. So let me just say about the track record. This really goes to the merger guidelines that they revised. But what is a demotion of economics, but a elevation of selective quotations from the case law is the use of this word may. It is true in this, in the Sherman Act it says may substantially, may, but it also says substantially. And the courts say, I'm not just going to stop something because it may have an adverse effect. So when the FTC and Department of Justice came out with their new guidelines, I was quite critical of them and wrote an article about it that explains what I think is wrong with them. Let me just give you some examples that goes to your question. The merger guidelines are, in my view, openly hostile to mergers. They're openly hostile to efficiencies. Now, there's some good economics in those merger guidelines, but that's in the back of the merger guidelines. And the front part of the merger guidelines are discussing a demotion of economic concepts for an elevation of concepts that are in the case law, sometimes old case law. And the word, I urge you to go through not only complaints that especially the FTC brings, but also that are in the merger guidelines. Look at the word may. Often, just put a circle how often that word may occurs. So I'm going to stop any transaction that may harm competition. Well, at the University of Chicago, I was in law school for a while, and Ronald Coase's office, who's a famous economist, very famous, and I would talk, and he says, Dennis, I'm struck by the fact that young economists like you often end their article by saying, a theoretical article that says, this may have profound implications for antitrust. Let me tell you something. If you see a sentence with the word may, you can also replace it with the word may not. And suppose you ended an article that says, my article may not have anything to do with anything. Well, that's when I see the word may now, I always think of Ronald. And that really, really worries me. So just to talk about the merger guidelines, they demoted economics. They put in the front of an economics section a whole bunch of case cites, some to old cases that most economists would disavow their logic. There are over 70 citations to cases in the new merger guidelines. In the previous merger guidelines, they were viewed as an economic handbook of how to analyze from an economic point of view mergers. There were 0 case citations. That really makes me nervous. It tells you I'm going to focus on cases, regardless of their economic logic, and I'm going to put the economists in the back. And I think that is motivating, and that's what I find fearful and dangerous about the agenda. It was why I wrote a letter. I helped compose and urge others to, together with Fiona Scott Morton, who has different views than me about antitrust, but we both shared the view that by putting the case law front and center in the merger guidelines, you were demoting economics. And that really worries me. And this word may, the place where it really raises questions is when you look at potential competition cases. I'm not going to allow this merger because firm A is taking over B and firm B may become a competitor to A. Really? How strong is the evidence? So if you allow may, it becomes speculative, and that really worries me. Now imagine you're an innovator in a high-tech industry, and you want to introduce some software product, and you come up with a great software product, but you don't have a clue how to monetize it. So you're hoping, gee, someone's going to see this whiz-bang software, and some company, maybe some big tech company who knows how to advertise, is going to buy me. Well, now if you're not going to allow that because you say, well, you know, Carlton, the innovator, might have turned into the next huge high-tech company, well, maybe I don't want to take that chance if I can't sell out. So those types of considerations in which your aggressive policy is undercutting really what would otherwise be good transactions, or in this case, investment in innovation, that's what really bothers me about May. But I think your question the next question on the agenda was rationales. So I wanted to talk a little bit about rationales because I did a little work on rationales. So the rationale, supposedly, for this more aggressive policy comes from a lot of sources. Some is populism, but some is some economic research that claimed to show that market power and competition were growing in the United States, and that lax antitrust was responsible. I've written an article about this. I'm not going to go through the article, but let me just cite 3 papers and just quote you. So I wrote a paper in 2020 in Competition Policy International where I reviewed the literature, supposedly providing a rationale for much more aggressive antitrust. My key conclusion is that although this literature raises issues deserving of continued research, and I agree it does, so just like what Debbie was saying, 6 to 5, 5 to 4, we can look at that and maybe decide, move the line a little. But I continue. Although this literature raises issues deserving of continued research, it does not support calls for dramatic changes in antitrust. Okay? Next paper from Georgetown's Nate Miller, who's now the chief economist at the Department of Justice. He wrote a survey paper, 2024. The studies do not point to weak antitrust enforcement as contributing to greater market power. Next paper, last one, Shapiro and Yurikoglu, 2024. We explain the empirical evidence relating to concentration trends does not actually show a widespread decline in competition, nor does it provide a basis for dramatic changes in antitrust. So my view is, to the extent you're basing a rationale on this literature that I was discussing in these other papers, it's exaggerating the rise of market power at the very, very least. The other rationale for the policy agenda, the more aggressive agenda, was that we needed to be concerned about topics other than just price and output. So, for example, we needed to be concerned about technological change. Well, as both Debbie and Bob said, those types of concerns aren't new. Economists would always be concerned if there was a reduction in technological change from a merger. And lawyers too, yes. And another new idea would be market power exercised against workers. Well, again, I can't think of any economist, or maybe antitrust lawyer, who would say that a cartel that exercises market power against workers is desirable. So those aren't new ideas, it seems to me. But there were other new ideas, as I mentioned, especially from the FTC, income distribution, political power, all of these new concerns. Those are concerns that I think are dangerous for antitrust to start being focused on, because if you focus on everything, you're going to wind up focusing on really nothing. So my own view is that the rationale that's motivating a much more aggressive policy is pretty weak, and My concern has been that the track record is quite choppy in the sense that there are, as Debbie said, I'll defer to the lawyer, her legal expertise, has been no change in the case law. I know there have been some cases with good language, some cases with bad language. That's what you expect if you bring lots of cases. What really is a mistake that the current administrations followed is they've neglected remedies as a solution to a problem. It used to be there could be contractual remedies. That seems to have gone by the wayside. They're not interested in that, even though the Department of Justice has endorsed in relatively recent cases, the NBC Universal, for example, the use of remedies. So my own view is the track record's not so great, chaotic, and that, again, I was worried about the agenda at the beginning, as I saw when I heard about it, and in light of the track record, I continue to be worried that it's imposing more costs than benefits.
Great. Well, Dennis, you covered a lot of ground, and I want to make sure Debbie and Bob have a chance to chime in on any of those topics that are of interest to you. But let me throw out a question to move ahead and maybe start, Debbie, with you and then Bob. Various of you have mentioned the FTC and DOJ, sometimes in the same vein, sometimes with, I detect a note of distinction. So if we look at the track record of the last 3.5 years, how would you differentiate the FTC and DOJ in terms of the rhetoric, the policies, the enforcement decisions, the litigation outcomes? Debbie.
Well, I think both have pretty much had the same rhetoric in terms of we need to do more, we haven't been aggressive enough. I think the FTC's been a little more critical of the past, whereas I think DOJ has just been we need to do more. Both have been incredibly critical of remedies. And I've talked to John Cantor about this and said, you can't never have a remedy. Like, why does everyone think you need to have 100% success rate on remedies when you're not going to have 100% success rate on litigation? And it's just a worldview that they just don't want to be the ones to take a risk. I think they would rather go to court and lose, because then they'll have done everything they can, than to have a remedy that doesn't work. And to be clear, Joe Simons, who was chair of the FTC under Trump, said much of the same thing, and I was equally surprised then, because there are times you go into remedies and you think, look, I don't know if this is perfect, but this gets us a lot. This gets us 90% of what we want, and it is not worth risking litigation to get the 10%. Now, if you're really unsure, I had somebody at the FTC, the way all remedies work is you have a compliance division, and they are separate from the litigating staff, from the investigating staff, and they decide whether or not remedies are going to be workable, and they consist of a lot of very senior folks, people who've been there decades, and one of them, a very good friend of mine, when we were seriously considering the remedy, and this is public, that we seriously considered a remedy in Cisco US Foods, at the end of every meeting, I would say, Eric, what do you think? And he'd say, it could work. And I was like, well, that's not my standard, right? I need to hear, I feel pretty good about this. And look, there are these couple of risk points. It could work. It may work was not enough for us if we thought that there was really a concern. But there seems to be no sliding scale anymore. It's just no. They both had successes. But I think I agree with Bob that they've been cases that we would have brought. And you can see this by the fact that the cases that they've won, Illumina Grail, which they say is so groundbreaking, was a 5-0 decision out of the commission. This tells me if Christine Wilson votes for a case, that most Republicans are voting for this case. She's pretty conservative, right? So this wasn't some groundbreaking. It was just, it happened to be a case that people didn't think could be remedied. But they've lost cases, and they've also had to walk back what they've done, what they've said, when courts start pushing back and they suddenly realize, you know what, I better settle this case even after I brought it because it's not going well. So differences on the margins, but not of kind in my view.
Yeah, I'll pick up on the remedies point, because it is worth emphasizing that that is a question that the agencies routinely come back to. What is working, what's not working, what have we learned from the ones that we've done? It's a nuanced question because, sometimes what you're actually trying to preserve is a company that's on the brink of failure, because that's actually great for competition as long as it lasts. But you want to keep, if you're divesting that, you don't want to then put on it some assurance that they're going to survive. That's the thing that, when I put my regulator hat on and talk to agencies that regulate firms, I often have to remind them, you actually do want these firms to be able to fail. If nobody can ever lose, you don't actually have competition. So it's hard to look at how successful have we been at remedies and just say, well, some of them failed. You would also need to look at the fact that some of them have succeeded wildly well. While I get lots of flack for being asleep at the switch, somehow I never get credit for the fact that America now has a #1 beer that is not made by AB InBev. We divested Modelo, the U.S. element of it. It has become the #1 beer in America. It's doing well as a competitor. Never seems to come up in these discussions about how remedies work or whether we should ever take a remedy. But remedy policy is something, I've been involved in multiple rewrites of remedy guidelines and remedy decisions about what kinds of things should we take or what kind of risks, what does work, what kind of assurances would make it more likely that it will replicate the kind of competition we had before. That's a normal question for an agency to be asking. How well am I doing my job? Being unwilling to consider, that's not a normal question for an agency. That's not a reason, just I don't like it. It sometimes doesn't work, or it's messy, or it makes me make decisions I don't like to make. That's not a reason to change the way you do your job. The other thing in the rationale category, Dennis mentioned, read some of the conclusions from eminent scholars such as himself on what this literature actually says. What he didn't mention is this literature is a recreation of a literature that people of our generation learned in IO boot camp long ago is a bad idea because it didn't work then. We tried to measure the structure of the industry or the amount of concentration in the whole US and say, how can we tie that to indicators of success or failure or prices or profitability or innovation? And it never worked. It was a terrible approach to academics, and we basically convinced ourselves it didn't work for good reason, because when you go and try and measure how concentrated is every industry in America, you would literally have to sit down and figure out what is the market for everything that's made in America. And we haven't actually done that. Instead, we came up with this set of industry definitions that we use for statistical purposes, but everyone who knows this literature knows you don't use it for measuring concentration. And oftentimes I would have to advise people from other jurisdictions who would call in and say, hey, DOJ, could you tell us what's the big book of concentration say about this industry? And I would say, we don't actually have those measures. Well, you have this NAICS codes that divide every industry up. Don't you know how concentrated they are? No, that's a terrible measure for it. We all know that. All the people who work with this know that. Then a bunch of macroeconomists got a hold of it, didn't ever have that training, and they said, oh, look, when we look at the concentration's going up tremendously in the U.S., and all these, any indicator you want of, what's wrong in America, look, it's negatively correlated with concentration because I've measured concentrations going up. Well, concentration's not actually going up. And you may think concentration's going up because there's a natural thing to pay attention to the companies you know, and you see that as time goes by, they become less dominant. I remember shopping at Sears and JCPenney. They are less dominant in retail now. If the two of, well, I don't even know if Sears is still alive at all, but if they had merged as they were going out of business, that probably wouldn't have been a big deal. But people who remember those are the big firms, they say, I've seen less and less competition here. You see this a lot of times when the agencies try and put up one of their favorite charts is, look, here's this industry, and there have been all these mergers, and the number of players has gotten smaller and smaller, and there's this category at the bottom that's kind of other. And other captures the fact that, well, you actually have new, say, airlines starting all the time. We recently had a litigation about Spirit Airlines. They didn't exist when this chart was put together, right? They're part of other. This notion that America has become much more concentrated in industry, that the big businesses have just become bigger, it's missing a critical thing that the nature of the American economy has changed over time. It's become a lot more focused on technology. It's become a lot less focused on Rust Belt industries, big heavy manufacturing, things that are measured well by certain models of competition and measures of concentration, such as the HHI. It's instead an industry that's an economy that's much more about innovation and coming up with the next big idea and getting it through all those steps to monetization, or really to distribution to users. That's a different type of industry. It's measured in a different type of model. It's not well measured in the kinds of things we see harped as, look how concentrated America has become. If you recognize that there isn't a concentration change, there's an industry change, there's a nature of what we're producing and how it's produced change, then you don't come at this with an attitude of, well, if we want to solve all these social ills, here's the root cause. It didn't change, so it can't be the root cause. If you want to solve those problems, you've got to look for an actual root cause.
Well, we're going to turn for home here. Excuse me. I'm going to throw it to John for a question I think he had on policy and legislation. And then I'll wrap up with a forward-looking question for all of you. But I just wanted to note that Bob's comment about macroeconomists reminds me of the old line that microeconomists are people who are wrong about specific things and macroeconomists are wrong about things in general. So
It's right between those.
there you go. So let me, John, I think you had a comment about policy and legislation, and then I have a sort of forward-looking wrap-up question for the panel.
Terrific. So far we've talked about antitrust enforcement as conducted by the agencies, by the FTC and DOJ. Over the last 3 years, there's been lots of talk about the need for remedying all those social ills that you spoke about, Bob, through additional new novel antitrust statutes. Just your reflections, maybe pretty quickly, on the need for new antitrust statutes to preserve competition. Do we need that legislation?
Maybe we need the legislation, but it is not a function of antitrust. As I've said repeatedly, there's an international CFIUS, right? Everyone knows the Committee on Foreign International Investment, whatever it is, investment in the US. And it's a group of people. There's also a telecom task force that looks at a whole bunch of different issues, and different parts of the government come together and decide what to do about a transaction. The antitrust folks have a seat at the table, but they are not the table. The economists at the FTC, at least the ones I worked with, would be the first ones to tell you, I can tell you pretty well whether or not a particular deal will have a monopsony power effect on the particular employees at issue. I cannot tell you whether a particular merger is good or bad for employment in the US generally. Will things get moved overseas? Is it more important to have jobs in Cincinnati? Bad example. I'm not going to use the Kroger headquarters. That was accidental. In Toledo than here because jobs are going to move, right? They don't know about that. But if you want to bring together the FTC to say, here's the impact on antitrust and competition, and the Labor Department to come in and say, and here's the effect on labor, and we want to have a domestic CFIUS to look at all transactions, go for it, right? I'm not going to be the one to say that Congress shouldn't do that. That's up to Congress. But I do not think that the antitrust laws are the cure of all evils, or that is the place to make those trade-off decisions. Antitrust should be about antitrust, and other considerations can be about other considerations, but you can't put them all under the umbrella of antitrust.
I would agree with that wholeheartedly. It's, if you have a multiple set of objectives you want to achieve, income distribution, employment, the movement in from one location to another of where production is taking place, those may be all fine objectives to be concerned about, but to have an antitrust law focused on that, or judges trying to figure out those trade-offs, unless you tell someone how to make trade-offs, they're just going to use their own views. And then you're going to devolve, antitrust will devolve into just whatever people's personal beliefs are and what they emphasize most heavily. So at least since the 70s, antitrust has been focused on a relevant question. Are consumers better off as a result? Are prices going to be lower? Are you going to get better products into the future? They do not focus on, am I protecting some group from competition? That would, such as small business, that would be the confusion between protecting competition, the process of competition, from the protection of competitors. It's a standard line in antitrust that you want to distinguish those two. It's the process you want to protect. You don't want to protect people from going out. But there is one thing I want to say about current issues, because one of the current issues has to do with some of these high-tech firms so big that you should be worried about power to censor ideas. The notion, the analogy people make that there's competition in the marketplace for ideas, that may be fine and dandy for metaphors. But from an economic point of view, what economists study is not competition for ideas. I mean, some may study that. But when we're talking about competition in the antitrust laws, I'm thinking about not the ability to spread false information, but rather, I'm producing a product, can I make it better or worse? Now, you may say, well, false information is a rotten product, but I don't have a mechanism, a clear mechanism how ideas compete with each other. And I think an analogy of saying ideas compete with each other, just like, brands of apples or different types of apples compete with each other, I'm not sure that's a very good analogy, because the best apple will be discovered by the consumer, okay, presumably. It's not obvious I'm going to be able to figure out who is the best and most reliable feed of information. So especially when you're in this realm of influencing public opinion, I think, and you're worried about that, I think, again, forcing antitrust to deal with a problem like that, it's not well suited, at least as based on the skills that economists are being trained with, and to burden antitrust with such doctrines, as well as other extraneous doctrines other than a consumer's help, and again, by consumers I would include workers, I think would be a giant mistake.
I want to get rid of the maze. I think it would be a bad thing to expand what antitrust law involves, mainly because I want to go back to that 1,999 mergers that ultimately should go through, right? The more things you layer on and add to this that aren't baked into that nuanced approach that the law has developed for figuring out how all the different issues weigh against one another, how the nuance of considerations that are both economic and legal about what makes for a credible prediction that something is going to lessen competition versus a more credible prediction that it's actually, if that merger were to happen, it's actually going to enhance people's lives. If you get rid of all that, or if you make it easier to ignore what Dennis called the economics, but I think of it as just the nuance, then you give more political power to hold up or tax the companies that the current administration wants to punish, and to use antitrust to dictate their behavior. And that has become a phenomenon that increasingly in the last couple of administrations has come to be too prominent in antitrust, even with the law we have. To further empower a political administration to have this as a lever to make businesses behave the way they want them to behave strikes me as cutting off your nose to spite your face. And I really don't want to see antitrust keep going down that path of being the tax that ensures businesses that whatever the current administration is doesn't like behave the way that administration wants them to behave.
Okay. Okay, well, let's wrap up with one forward-looking question. I had two of them, but I'm going to merge them into one in the interest of time. Feel free to address either piece of this. So the first piece is, if the current administration in antitrust came to an end, what would be the legacy? Have they moved the needle in public opinion, the courts, Congress? And the second question is, do you think that they will come to an end? And I ask that not because you're expected to predict the outcomes of what looks like a very, very close election, but the matrix is actually more complicated than that, because on the Democratic side, we will have a new Democratic president who may or may not follow all of the economic policies of the previous one, perhaps including antitrust. And on the Republican side, it's even more complicated, where we have traditionally a pro-business wing of the party, I guess, still. And then we have the populist wing, exemplified by J.D. Vance, who has said that he thinks Lena Khan at the FTC is doing a pretty good job. So either part of that question, fire away.
I'll go first, because it continues the theme that I was just on. I see the fact that the populist wing of each party is kind of liking the attacks on tech. I see that as just the worst possible. I would love for them to get along on more substantive things. I hate for them to get along on this idea of, it's great that we can punish the companies that we just happen to both dislike. To me, this is the one thing that I worry is the legacy here, is that it's kind of entrenched something that it didn't start with this administration, but it has kind of entrenched it or moved us closer to it being entrenched in a way that I find dangerous. What I find encouraging or possibly the silver lining on either, however this election comes out, is that, whatever you want to call it, the pro-business wing or or Harris's statement that, where she wants to go after high prices, it's with something that is nuanced to like price gouging only, not something that looks more like price regulation, as far as I can tell. That's encouraging to me, because it kind of puts us back a couple of administrations in where we would be, and maybe gives us a chance to get antitrust to be about competition again, and to be wrestling with the tricky questions it's always wrestled with. How do we identify the deals or the behaviors that really are problematic? How do we find remedies to those that are most likely to work, and go about it based on what the facts and the law really say about that?
In the past, there haven't usually been huge pendulum swings. This is a bit unusual. When Clinton turned into Bush and Bob Pitofsky left and Tim Uris came over, in Tim Uris's first speech, he praised Bob Pitofsky. That is not something that is happening now, that they're praising the prior enforcers. And when you look at some of the best things that the FTC has done, it's been kind of this baton pass handoff. Reverse patent settlements across administrations, hospital merger challenges across administrations. Everybody's built on things. They've taken the baton and they've kept going. This has been unusual. I think that we're not going to see a radical shift, whether it's Harris or Trump. In fact, Trump 1 tells you they pretty much kind of kept things. There weren't big differences between what they did and what we did. I mean, I talked to Joe Simons, who was chair of the FTC, after I had given a speech right around, I think it was the summer that I was in between leaving the government and going back, so I could say whatever I wanted. And he came up to me afterwards and said, the dirty little secret is that you and I are about this far apart. And I think that's right. I mean, most antitrust lawyers are within a very narrow spectrum. They follow the law. They think about things the same way. There are always going to be differences on the margin, and that's because there are sometimes hard cases and a question of where you draw the line on may. I used the example, there was a case that staff was thinking about bringing, and I said, I'd really like to hear what the economist who would be our testifying economist would say, very prominent economist. He said, here's the case I would make about why we should challenge this deal. And he went through this incredibly beautiful storytelling story. And I said, wow, that sounds great. He said, wait, I could also tell you this story. And he goes through everything and he tells me all the reasons that this deal is going to be the greatest thing since sliced bread. And I said, and he says, and I cannot tell you which outcome is more likely than not. How do you bring that case, right? This administration might. We were not prepared to bring that case when we all sat around and talked to it because I didn't want to put an economist on the stand who said, I don't really know. It could happen either way. We haven't seen the bad effects happen. So I don't think there will be huge changes. I think the rhetoric will tone down. I think we'll see, like we said, many of the cases that are brought, anybody would brought. There are always the handful of cases on the margin that get debated about. That happens in any administration. I think we'll continue to see that.
I guess my view is I agree with something Debbie said earlier, that certainly this administration has succeeded in elevating antitrust in the minds of the public. Whether that's good or bad, I think remains to be seen, because I think that the rise of populism is dangerous, not just for antitrust, but generally for the country, and that both parties are involved. That's why I don't know whether antitrust is going to change very much, depending on who gets elected, although I do suspect it would be more aggressive under Harris. Especially if Lina Khan remains. Like I say, it's populism that really worries me. And what really worries me is how often I hear people using the notion that it's corporate greed that I am going to protect the American public from. And I know it's politically popular to say for people in the administration, or even if you're a Republican, and that kind of makes me nervous, because it's slamming really. No one is for greed. Can you imagine someone? The definition of greed is an insatiable desire to achieve wealth at any cost. Now, can you imagine a politician say, "Oh, I disagree. I'm for greed"? It just is. So when someone gets up there and bangs on the table and says, it's corporate greed I'm against, and that's what this lawsuit is, I kind of wince and worry that it's appealing to people's sort of the population's desires to hit back at someone who has a lot of wealth. Maybe it's big companies. You might want to do that. You might want to, raise the income tax to redistribute income. But don't say that every corporation that's big is bad. That's what really, really worries me. And it could devolve into a situation in which more well-organized groups are going to get political power to get protection from competition. And we see that happening throughout the economy. And I just worry that that's going to have appeal as a result of populism to political groups. And that would be terrible for consumers. And that's what antitrust has tried to be above. Consumers in general benefited by this conduct. Consumers in general benefited from a merger, even if large firms involved. And what I caution everybody, and this happened when I was in the Justice Department, it was in 2007, roughly, and there were programs then that we put on to attract foreign antitrust officials so that they would understand the antitrust laws. And I said to myself, we're not doing a very good job, America, compared to, say, Europe in what they were trying to convince regulators to do, including their own. If you compare innovation in Europe to innovation in the United States, if you compare who are the top innovative companies in Europe, how many are there, to the top innovative companies in the United States, I urge you to do that comparison. So if you think the regulatory policy of Europe or the antitrust policy of Europe is desirable for innovation, just do that calculation, and I think the answer will be clear. So my view is, I'm worried about the future. I'm worried about the future not just for antitrust, but for the influence of populism. But I hope that I would say, unmooring of aggressive antitrust from economic considerations will cease, and we'll get a more rational policy going forward. And I do hope that the merger guidelines quickly get revised, the new ones, so that they are turned back into an economic analysis of a merger rather than anything else.
Okay, so let me just say that I hope all of you here and all of the folks online have enjoyed this discussion half as much as I have. I think we have had a fulsome, rich, insightful discussion from three of the nation's preeminent experts in antitrust law and economics. This will be available as a video that you may actually want to rewatch. I know I will. So for those of you who are here in the audience in person, we're going to recess, go have some lunch, mingle amongst ourselves. If you have questions for the panelists, please feel free to weigh in with questions as we go downstairs. For those of you who are online, too bad, you don't get lunch. Come to our events. Thank you very much.